Good morning, Alex and friends. I'm Grace. Today is Saturday, February 14th, 2026, and you're listening to Alex's News. The high in Riverside today is 66.4 degrees, with a low of 47.5, making for a mild Valentine's Day perfect for a romantic stroll or cozy indoor plans. Happy Valentine's Day! Coming up, we'll examine how a shooting involving ICE agents escalated into a perjury investigation targeting federal officers and break down the Trump administration's EPA decision that has undermined the core legal framework for U.S. climate protections. Plus, other key stories on national and global developments. All this and more on Alex's News. Stay tuned. Federal authorities are now investigating two immigration agents, not for a shooting, but for possibly lying about it under oath. It all centers on a Venezuelan man shot in North Minneapolis last month. Ethan, bring us up to speed on what happened here.
This started back on January 14th, about a month ago, during a Trump administration immigration crackdown in the Twin Cities that local outlets have been calling Operation Metro Surge. According to reporting from Sahan Journal through the Associated Press, as well as Le Monde English edition, ICE officers tried to pull over a car driven by a Venezuelan immigrant named Alfredo Alejandro Aljorna in North Minneapolis. Federal documents say he crashed, ran to the duplex where he lived, and that an ICE officer was then ambushed and nearly killed in a violent attack. That story was used to justify criminal charges, accusing Aljorna and his friend, Julio Cesar Sosa Celis, of felony assault on a federal officer.
So this begins as a traffic stop gone bad. What exactly did that ICE officer say happened at the duplex door?
In the original FBI affidavit, which outlets like Sahan Journal and the Washington Post have summarized, the key officer claimed Aljorna and Sosa Celis jumped him at or near the entrance. He testified that the two men, along with an unnamed third person, beat him on the ground with a broom handle and a snow shovel, and that he fired a single defensive shot because he feared for his life. That bullet hit Sosa Celis in the right thigh, and agents later used tear gas to force the men and two small children out of the upstairs unit where they had retreated. It was painted as a textbook case of an officer under deadly attack who had no choice but to shoot.
And top Trump administration officials really ran with that story the very next day, right?
They did. On January 15th, so about a month ago tomorrow, Homeland Security Secretary Kristi Noem called it, quote, attempted murder of federal law enforcement, end quote, according to Sahan Journal and CBS News. She said a lone ICE officer had been ambushed by three men wielding shovels and broom handles, and that he fired a defensive shot to save his own life. Noem also blamed Minnesota's Democratic Governor Tim Walz and Minneapolis Mayor Jacob Frey, accusing them of encouraging people to impede and assault federal officers, which she called a federal felony. All of that rhetoric is now badly out of step with what video and eyewitnesses show.
Let's talk about those other accounts. When the men got into court, how did their lawyers and witnesses describe that doorway confrontation?
At a detention hearing on January 21st, about 3 weeks ago, the officer's sworn story was challenged from several angles. Sahan Journal and Minnesota Public Radio report that Aljorna's attorney, Frederick Goetz, did concede his client had a broomstick and tossed it toward the officer while he was running into the house, but he flatly denied any prolonged beating on the ground. Julio Sosa Celis defense lawyer Robin Wolpert said her client had a shovel but was retreating into the home, not attacking, when he was shot. A neighbor and the men's partners also testified that the men were moving away from the officer, trying to get inside, and none of those civilians backed up the claim that the officer was pinned down and being beaten with a broom and shovel.
One of the big disputes is whether that shot went through the front door. What are the defense lawyers saying about that?
Immigration attorney Brian Clark, who represents both men in immigration court, told Sahan Journal and Le Monde that the agent, quote, recklessly shot into their home through a closed door, end quote. Defense lawyers argue the key moment was not a ground fight at all, but the officer firing as the men tried to close the door, or even after it was already shut. Judge Paul Magnuson, the federal judge handling the case, later flagged that same question in his order, asking whether the shot came before or after the men got inside. That timing goes to the heart of whether this was self-defense or an unjustified use of force at the threshold of someone's home.
Then, earlier this month, new video surfaces and everything shifts. What do we know is actually on that footage?
The video itself has not been released to the public, but its contents are described in court filings and in coverage by The Washington Post, The Guardian, PBS NewsHour, and others. Prosecutors now admit the footage does not show the officer being beaten with a broom handle and snow shovel, and there is no visual support for the supposed ground struggle he described. According to those summaries, the video shows Julio Sosaceles holding a shovel at one point but moving away from the officer, heading back into the duplex, and the officer firing as the door is closing or has already closed. It also fails to show any third attacker, even though that alleged third assailant was central to the ambush story that Secretary Noem promoted.
Once prosecutors had seen that, how quickly did the criminal case against these two Venezuelan men fall apart?
It unraveled very fast. On Wednesday, February 12th, 2 days ago, U.S. Attorney Daniel Rosen filed a motion describing the footage as, quote, newly discovered evidence, end quote, that is, quote, materially inconsistent with the allegations in the complaint affidavit and with prior hearing testimony, end quote, as reported by Sahan Journal and Le Monde. Then yesterday, February 13th, Rosen took the extraordinary step of asking the judge to dismiss all felony assault charges against Aljorna and Sosaceles with prejudice, which means the government cannot simply refile them later. Judge Magnuson granted that request, noting that the original ambush narrative no longer held up in light of the video, and the criminal case against the men effectively ended on the spot.
How are the men and their lawyers describing what this ordeal has been like for them?
Brian Clark has been blunt, telling reporters the original complaint was based on lies by an ICE agent who, he says, recklessly fired into a home through a closed door. He says his clients are relieved, even overjoyed, that the charges are gone, but they have already suffered a gunshot wound, weeks in custody, legal bills, and deep trauma for their families. Robin Wolpert, who represents Sosaceles in the criminal case, said, quote, my client is a crime victim, end quote, not a perpetrator, and she has pushed for the shooting officer to be publicly named and criminally charged. Both men, their lawyers emphasize, have no violent criminal history and were working night shifts as food delivery drivers precisely to avoid encounters with immigration enforcement.
Now the spotlight has swung around to the ICE officers themselves. What exactly are federal authorities investigating them for?
Yesterday, the same day charges were dropped, ICE Acting Director Todd Lyons announced that ICE and the Justice Department have opened a joint criminal investigation into two officers, according to the Toledo Blade and The Guardian. Lyons said video shows that sworn testimony by two different officers appears to have included untruthful statements, and he stressed that, quote, lying under oath is a serious federal offense, end quote. Both officers, who have not been publicly named, are on administrative leave and face potential termination and possible federal perjury charges, though none have been filed as of this morning, February 14th. Legal experts interviewed by The Guardian point out there is precedent, like the 2006 prosecution of Border Patrol agents Ignacio Ramos and Jose Compian for charging federal officers when they allegedly cover up shootings with false reports.
There is also this third Venezuelan man from the duplex who was almost whisked out of state. Why has he become such a key figure?
That is Gabriel Alejandro Hernandez Ledesma, who lived in the downstairs unit of the same duplex. Sahan Journal and Le Monde report he was arrested the same night as the shooting, but never charged with any crime. Instead, within hours, ICE flew him to a detention facility in Texas, without a warrant, according to a January 30th court filing. His lawyers argue that move was a deliberate attempt to get a critical eyewitness out of Minnesota before he could contradict the federal narrative or assist state investigators. A federal judge later ordered Hernandez Ledesma brought back to Minnesota and released, and that episode has fueled accusations that officials were more interested in protecting their story than in preserving testimony.
Minnesota is also trying to investigate the shooting itself. How is that state-level probe going, especially with the FBI involved?
State authorities, including the Minnesota Bureau of Criminal Apprehension, have opened their own criminal investigation, but it has been an uphill climb. According to PBS and the site newsfromthestates.com, the FBI, which led the initial federal probe and produced the now discredited affidavit, has refused to share key evidence, including the shooter's name, and has not made that officer available for a state interview. That stonewalling has slowed the state case and sparked questions in local media about whether federal agencies are obstructing accountability. Legal scholars note that the Constitution's Supremacy Clause does not give federal officers blanket immunity. If investigators can show an agent acted with malice or outside lawful duties, state charges for assault or even attempted homicide are at least theoretically on the table.
Even with the criminal case gone, these men still have to worry about immigration. Where do things stand for them on that front?
Their legal situation is better, but far from settled. Outlets like Sahan Journal and News from the States report that ICE has tried at various points to redetain Aljorna and Sosa Celis and move them to detention centers outside Minnesota. The chief federal judge in the district, Patrick Schultz, stepped in and ordered that they cannot be removed from the state, recognizing them as crucial victims and material witnesses in the Perjury investigation. Immigration experts told reporters that, because they are alleged crime victims who are now helping law enforcement, they may qualify for special visas that protect cooperating victims, and courts have repeatedly said the government cannot simply deport key witnesses while a criminal probe is ongoing.
Politically, this is also a big test for Secretary Noam and Operation Metro Surge. Has she backed off those tough early statements at all?
Not so far. As of today, February 14th, Le Monde and CBS News report that Kristi Noem has not retracted her description of the incident as attempted murder and domestic terrorism, even though the Justice Department has dropped all charges and ICE has acknowledged untruthful officer testimony. A Homeland Security spokesperson has declined to say whether she still stands by her original language, now that the narrative has flipped. In Minnesota, meanwhile, Mayor Jacob Frey has called the initial federal story, quote, garbage, end quote, and Governor Tim Walz and other Democrats argue Operation Metro Surge has sown chaos and distrust by bringing heavily armed federal teams into city neighborhoods and then exaggerating what happens.
Finally, Ethan, step back for us. How does this Minneapolis case fit into the wider pattern we have seen with federal immigration enforcement?
Sahan Journal and Le Monde both point out this is not an isolated incident. During the broader Trump-era crackdown, there have been several high-profile shootings by immigration agents, including fatal ones in Minnesota, like those of Renee Good and Alex Preddy, where official self-defense stories were later questioned in light of video or new witnesses. Around the country, The Guardian notes that a number of felony cases accusing protesters of assaulting federal officers have also collapsed once video undercut the government's claims, revealing a pattern where the initial law enforcement narrative gets wide play, but does not always survive close scrutiny. In Minneapolis, what began as a supposed ambush of an ICE officer is now fundamentally a story about truthfulness under oath, accountability for federal agents, and the particular vulnerability of non-citizens when they are up against the machinery of federal enforcement.
A complicated case that is still unfolding on several fronts. Ethan, thanks for walking us through it. We're back, and we're turning to what may be the biggest climate story in years. The Trump EPA just wiped out the federal government's core climate finding for cars. Chloe is here to walk us through it. Chloe, what exactly did they do this past Thursday?
On Thursday, February 12th, the Environmental Protection Agency finalized a rule that rescinds the 2009 greenhouse gas endangerment finding for motor vehicles. According to ABC News, that finding has been the legal backbone for federal climate rules on cars and trucks for well over a decade. By scrapping it, the Trump administration is also repealing every federal greenhouse gas standard for new vehicles and is openly inviting the courts to say EPA has no climate authority under the current Clean Air Act.
Let's back up, because that endangerment finding sounds pretty technical. What was it, and why did it matter so much?
The finding grew out of the Supreme Court's 2007 Massachusetts versus EPA decision, which said greenhouse gases count as air pollutants under the Clean Air Act. The court told EPA that if those pollutants endanger public health or welfare, the agency must regulate them from new motor vehicles. So in 2009, the Obama-era EPA did a massive scientific review and concluded 6 greenhouse gases collectively endanger Americans by driving climate change, and that vehicle emissions contribute to that danger. The D.C. Circuit later described the evidence behind that as, quote, an ocean of evidence, end quote, and as the Washington Post notes, no court has ever struck it down.
And over time, what did that finding actually unlock in terms of policy?
It became the legal trigger for federal tailpipe greenhouse gas limits on cars, pickups, SUVs, and heavy trucks. It also underpinned carbon rules for power plants and industrial sources because the same scientific conclusion that these gases endanger health and welfare carried across the Clean Air Act. ABC News points out that it shaped fuel economy planning, emissions reporting, and the entire trajectory of vehicle technology for more than a decade. In a real sense, it was the core legal statement that climate pollution is something EPA has to deal with, not just something it may choose to.
So the first Trump term pulled back a lot of those rules, but never went after the core finding itself. What changed in his second term?
According to Time and the Washington Post, the strategy in the first term was to weaken or replace rules on vehicles, power plants, and methane, while leaving the endangerment finding alone because it was seen as legally solid. In January of last year, on Inauguration Day, President Trump signed an order called Unleashing American Energy that told EPA Administrator Lee Zeldin to reevaluate the 2009 finding. By late July, Zeldin proposed repealing it, and all the vehicle greenhouse gas standards tied to it, calling that proposal, quote, the largest deregulatory action in the history of the United States, end quote. Thursday's rule turns that proposal into reality.
What's the basic legal theory the Trump EPA is using to justify throwing out that earlier finding?
The new rule leans hard on 2 recent Supreme Court developments. First, in Loper Bright Enterprises versus Raimondo in 2024, the court ended what is known as Chevron deference, meaning courts no longer automatically defer to agency interpretations of ambiguous laws. EPA now says that under its own best reading, the Clean Air Act's vehicle section was really meant for local pollutants, like smog, not globally mixed gases like carbon dioxide. Second, they invoke the major questions doctrine from the West Virginia versus EPA case, arguing that using a 1970s provision to reshape the entire transportation sector's climate pollution is a decision of vast economic and political significance that Congress never clearly authorized.
And how does that square with Massachusetts versus EPA, which seemed to answer some of those questions already?
That's where the fight really sharpens. In Massachusetts versus EPA, the Supreme Court read the statute itself, without leaning on Chevron, and said greenhouse gases fit comfortably within the Act's very broad definition of air pollutants. It also pointed out that Congress explicitly mentioned climate and weather in the definition of public welfare, which undercuts the idea that only local smog counts. State attorneys general and legal scholars quoted in the Associated Press say EPA cannot reinterpret away a Supreme Court ruling just because Loper Bright made life harder for agencies. In their view, Massachusetts is still binding law unless the Supreme Court narrows or overturns it.
Let's talk about the science, because the administration keeps saying the 2009 science was wrong or outdated. What's EPA claiming there?
The new rule does not deny that greenhouse gases warm the planet, but it tries to soften the word endanger. According to ABC News, EPA argues that the 2009 judgment relied heavily on earlier UN science that supposedly overprojected near-term warming compared with certain satellite records. It highlights a handful of studies that suggest lower climate sensitivity to carbon dioxide, implying the worst-case warming projections are less likely. And it claims that societies have become less vulnerable since 2009 through air conditioning, medical advances, and agricultural innovation, so the net level of endangerment is lower than EPA once thought.
And how are scientists and big cities like Chicago responding to that argument?
Chicago's mayor, Brandon Johnson, called the rule, quote, "A chainsaw to science and a capitulation to corporate profiteering," end quote, in a statement Thursday. The city accuses EPA of cherry-picking fringe or climate denialist sources while ignoring the latest major assessments that show climate impacts worsening, not easing. ABC News points to the 5th National Climate Assessment and a 2021 study in Nature Climate Change, estimating that more than a third of recent heat-related deaths are due to human-driven warming. For communities already dealing with extreme heat, floods, and polluted air, often black and brown neighborhoods, Chicago and health experts argue that the idea of less endangerment is simply detached from reality.
The administration is also talking a lot about money, not just science. What economic case are they making?
The White House and EPA claim this repeal will save roughly $1.3 trillion in compliance and technology costs through mid-century. Administrator Zeldin says that without climate-driven requirements, new gasoline vehicles can be $2,400 to $3,000 cheaper per car, which he frames as relief for working-class buyers. According to the Energy Marketers of America, or EMA, the rule also eases what they call a forced transition to electric vehicles, preserving stronger and longer-term demand for gasoline and diesel. Critics respond that those savings ignore the enormous costs of climate damage, fires, floods, heat, and health impacts that taxpayers and households ultimately pay.
So when this rule hits the books, what changes immediately for cars and trucks on the road and in the showroom?
For new vehicles, all federal greenhouse gas limits and related reporting obligations vanish going forward. ABC News notes that includes the Biden-era standards for model years after 2027, which were projected to avoid more than 7.2 billion tons of carbon dioxide through 2055 and save the average driver thousands in fuel and maintenance. Automakers still have to meet separate safety and some pollution rules, but there's no federal cap on climate pollution from new cars or trucks anymore. Over time, analysts say that could slow or reverse adoption of certain efficiency technologies, especially ones that only made business sense because they earned greenhouse gas credits.
Does this decision also spill over into power plants and other big emitters? Or is it really just about vehicles?
Formally, this rule is targeted at motor vehicles under one Clean Air Act section. But as legal commentators told The Washington Post, the logic is much broader, because the same endangerment conclusion supports carbon limits on power plants and large industrial sources. If courts accept the idea that EPA misread its authority on greenhouse gases for vehicles, that reasoning could be used to undercut climate rules across the board. So while many specific power sector rules have already been pared back, this move is widely seen as an attempt to pull the Clean Air Act itself out from under future climate regulation.
You mentioned states and cities earlier. How quickly did they react, and what are they planning to do?
Within hours on Thursday, California's Attorney General Rob Bonta and Governor Gavin Newsom said California would lead a multi-state challenge in the D.C. Circuit. According to CalMatters and the Associated Press, that coalition already includes states like Massachusetts, New York, and Michigan, plus big cities like Chicago, New York, and Los Angeles. They argue EPA is openly defying Massachusetts versus EPA and acting arbitrarily by brushing aside an even stronger scientific record than existed in 2009. Environmental groups like the Sierra Club, NRDC, Earth Justice, and the Environmental Defense Fund are filing parallel lawsuits, often in coordination with those states.
How are those lawsuits framing the clash with this new reading of the law?
They're making 3 big points. First, they say Massachusetts versus EPA remains controlling because the court itself decided that greenhouse gases count as pollutants and that EPA must regulate if it finds endangerment. Second, they argue the major questions doctrine is being twisted here, since Congress already answered the question in 1970 by writing a technology-forcing law that uses the word shall once danger is found. Third, they say the rule is arbitrary and capricious. because EPA is ignoring overwhelming, updated evidence of harm and counting only industry compliance costs while leaving out the trillions in climate damages documented in the National Climate Assessment and elsewhere.
There's also this separate fight over what states like California can do if EPA walks away. How is that playing out?
Under the Clean Air Act, states are generally barred from setting their own new vehicle emission standards, except that California can seek a waiver to go further, and other states can then follow California. EMA reports that even as EPA relinquishes its own greenhouse gas standards, it is still claiming that federal law preempts most state efforts in this space. California and its allies counter that if EPA says it lacks authority over vehicle climate pollution, it cannot also block states from stepping into that vacuum. The auto industry warns this could create a confusing patchwork of state rules, but California officials say the alternative is simply no climate protections at all.
Speaking of industry, how are automakers and fuel suppliers reacting to this sudden shift?
It's mixed. Legacy U.S. automakers like Ford and GM have poured tens of billions of dollars into electric vehicles, and business outlets cited by Yahoo News say some of those bets have been painful. Ford has praised the move for restoring what it calls customer choice, but its executives and their trade group still say they prefer a single national standard to constant regulatory whiplash. The Energy Marketers of America, which represents fuel distributors, welcomes the slower push toward electrification, seeing stronger gasoline and diesel demand, yet even they warn that a long court battle and diverging state policies could make planning and investment much harder.
For listeners wondering what happens next, on what timeline do we expect this to play out in the courts?
The rule is already final, so it is technically in effect now, but states and environmental groups are asking the D.C. Circuit for an emergency stay in the coming weeks. Legal experts quoted by the Associated Press and Inside Climate News expect arguments at the appeals court later this year, and then almost certainly a trip to the Supreme Court by late next year or early 2027. The justices will not just be deciding whether this one rule stands, they will be effectively deciding whether the Clean Air Act can still be used to tackle climate pollution in any meaningful way. Until then, automakers, states, and cities are stuck planning for several very different futures at once.
And there's even talk this could backfire on industry by weakening their defenses in other kinds of climate cases. What's that about?
Some legal commentators, including those quoted in The Guardian and Mother Jones, point out that big oil and utility companies often argue that federal regulations already cover climate pollution, so state law nuisance suits are preempted. If the Supreme Court ultimately guts federal climate authority, those preemption arguments get weaker, not stronger. That could open the door to more aggressive state and local lawsuits seeking damages for climate harms, from coastal flooding to wildfire losses. So even as federal rules recede, corporate exposure in court could actually grow.
So bottom line, as of today, February 14th, 2026, how should people understand the stakes here?
In simple terms, this is a bid to erase the government's own conclusion that climate pollution from vehicles endangers Americans, and to stop future presidents from using existing law to do much about it. According to ABC News and legal scholars across the spectrum, it is the most direct assault yet on the legal foundation of federal climate policy. Whether it stands will depend on how far the current Supreme Court is willing to go in rereading its own Massachusetts versus EPA decision. The outcome will shape not just what cars we drive, but how, or even whether, the United States regulates greenhouse gases at the national level.
A lot to watch in the months ahead. Chloe, thanks for breaking that down for us.
Thanks, Grace.
Here are some other headlines. At the Munich Security Conference in Germany, United States Secretary of State Marco Rubio is striking a softer tone but keeping a hard line. In a keynote today, February 14th, 2026, he portrayed America as a child of Europe and said the continents belong together, a lullaby of unity after years of transatlantic static. Rubio called for a reinvigorated alliance that rejects what he labeled the West's managed decline, even as he criticized the United Nations for playing virtually no role in conflicts like Gaza, and voiced doubt that Russia is serious about peace in Ukraine as the war nears its 5th year. Leading the largest United States delegation ever to Munich, including over a quarter of the Senate, he sketched a new world order grounded more in national sovereignty than old-school multilateralism. On the streets outside that same conference, Iran's opposition is turning protest into a global chorus. Exiled Crown Prince Reza Pahlavi has declared today a global day of action, with large solidarity rallies in Munich, Los Angeles, and Toronto, backing Iran's anti-government movement. At home, where a brutal crackdown has left at least 7,005 people dead, security forces have shifted from street battles to a surveillance dragnet, using video to haul thousands from their homes. Authorities have now, for the first time, admitted that university students were killed during the peak January unrest. Human rights monitors estimate more than 50,000 people have been detained since the uprising began in late December 2025. With an extra United States carrier strike group steaming into the region and President Donald Trump openly favoring regime change, if nuclear talks in Oman fail, activists are pressing Western leaders to turn supportive words into sanctions and diplomatic isolation of Iran's rulers. In Washington's health policy arena, Dr. Mehmet Oz is trying to turn rural care from house call to call center. As head of the Centers for Medicare and Medicaid Services, he is pitching agentic AI and digital avatars as stand-in staff for underserved communities, arguing software could handle intake and tailor treatment for about $2 per hour instead of $100 for a human physician. The plan is the marquee feature of a $50 billion rural health transformation program that leans on drones and robotics, even as Medicaid budgets are cut. Oz says it will, writes Eyes, care for roughly 60 million rural Americans, but critics warn that dressing abandonment and high-tech scrubs is no cure, and fear the access model, due to launch in July 2026, could replace too many humans with holograms. The Epstein saga is no longer just gossip at high altitude. It is causing real-world turbulence in boardrooms and parliaments. After the court-ordered release of roughly 3.5 million documents under the Epstein Files Transparency Act, DP World's longtime chief, Sultan Ahmed bin Sulayem, abruptly resigned following disclosures of extensive emails with Jeffrey Epstein. Goldman Sachs's top lawyer Catherine Rumler is also stepping down after records showed she advised Epstein while maintaining a personal rapport. In Britain, former cabinet minister Peter Mandelson has quit the House of Lords and now faces a Metropolitan Police probe into allegations he leaked market-sensitive information to the financier in 2009. In Norway, ex-Prime Minister Thorbjorn Jagland has been charged with gross corruption after his diplomatic immunity was lifted to examine Epstein-linked gifts and travel. On Capitol Hill, Representatives Thomas Massey and R.O. Khanna are sparring with Attorney General Pam Bondi over what they call excessive redactions. Khanna has already had to retract the naming of 4 supposed associates, saying the Justice Department failed to note they appeared only in an innocent FBI photo lineup. The wider fallout is transforming the case from salacious sideshow into a serious test of public office integrity and corporate conduct, as the House Judiciary Committee probes claims the Justice Department monitored lawmakers' work with the unredacted files. Finally, in auto safety, Congress is putting the brakes on efforts to stall anti-drunk driving tech. A Republican push to defund mandatory impairment detection sensors in all new United States vehicles has failed in the House, where lawmakers voted 268 to 164 to preserve the HALT Drunk Driving Act provisions originally tucked into the Bipartisan Infrastructure Law of 2021. With funding protected, federal regulators at the National Highway Traffic Safety Administration are weighing passive air monitors and eye tracking systems before reporting back to Congress. Mothers Against Drunk Driving calls the move a landmark toward preventing more than 10,000 alcohol-related deaths each year, while critics, including Florida Governor Ron DeSantis, deride the technology as a government kill switch. Automakers, insurers, and even parts of the spirits industry are now passengers on the same policy train. As experts forecast a final rule around 2027, and roll out in new cars between roughly 2029 and 2030. That's all we have for now. Today's episode was made by Alexander King with GPT 5.1, Gemini Pro 3, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.